that was laid over from last Wednesday's meeting. Before we begin, because of the necessity of the subject matter that we're talking about, there's three housekeeping matters to go over. First and foremost, I want to remind all the council members that what we're voting upon and what we're discussing is our recommendations to RIRA as to the purpose of the application. We are not a body in itself, has the power and empowered to, nor have the fiduciary capabilities to release public funds. So therefore, I want you to all be cognizant of the fact that what we're discussing may very well, or what may be voted on, may very well be changed on the higher ups. But for the purposes of today, it is the recommendation of what the Common Council will be as to the allocations that have been applied for. Secondly, because of the nature of the recommendations and allocations, questions have come up concerning conflicts of interest. The standard conflicts of interest that have been asked, that have been by law, by statute, that's applicable to these proceedings are the ones that RIRA has asked the PPF committee members to sign as part of their vetting process to sit on the PPF committee who had heard the original applications. The affidavit and the standard set forth in the application is the actual legal standard for the purposes of these funds. And so I'm going to go ahead and first proceed to read what that standard is. Number two, like you all know, identify who, based upon the disclosures of the organization, fit within that standard and have a clear conflict of interest and what will happen with those individuals. And then number three, ask that if there are any individuals that were not identified, that those individuals self-identify, self-audit, and state whether or not they believe that they may have a conflict, and we'll discuss the same. So the standard that the PPF committee was asked to sign, the affidavit and the standard by which the PPF committee was asked to abide to and sign for purposes of making the recommendations is that the undersigned declares and affirms that he or she shall not recommend grants for any organization in which he or she directly or indirectly through business, investment, or family have or negotiate to obtain an ownership or investment interest or a compensation arrangement, or from which he or she otherwise expect to receive any direct benefit not otherwise available to the community. Does anyone need me to read the standard again? This is the legal definition of a conflict of interest for purposes of disbursement of public funds. Having said that, both the chair of the ethics committee, myself, and also the chair of the PPF committee have gone over the disclosures of the RIRA members, Common Council members who are here today and who are otherwise members of RIRA. And there are two individuals who have been identified that triggered this clause. The first is Lynn Shinozaki, who is not here. She is listed on her disclosure form as a trustee of the Roosevelt Island Residents Association. So therefore, she has obviously a direct benefit. Her organization is a member of it, has a direct benefit, and would have an interest in the compensation or the disbursement that is being discussed today. The second is John Doherty, who is the chair of the MTS, or is it director of the MTSDA? Okay, board member, I apologize, of the MTSDA organization, which is the Main Street Theater Dance Alliance. For the purposes, I guess, for John Doherty, for today's matter, you cannot vote on any of the matters today and engage in any substantive discussion. We will not participate in procedural motions and non-substantive motions, but other than that, I ask that you refrain, and I will be watching very carefully the comments and debates. Having read the standard as to what constitutes a conflict of interest, are there any other individuals who have not been identified who must self-audit or disclose a possible conflict? All right, seeing none, we're going to go ahead and proceed.